Welcome to the Dealmaking with Laura DiFrancesco podcast. I'm Laura DiFrancesco, your host. We're talking all about mergers and acquisitions, buying and selling small businesses, as well as corporate law. We are taking our experience closing over $10 billion of transactions since founding Dean Street Law 5 years ago, and my experience being an M&A and corporate attorney for over a decade and making it accessible to you as an entrepreneur. I hope that this helps you in navigating the complex world of mergers and acquisitions. And also, we're always happy to be a resource for you here at Dean Street Law. You can always apply to work with us through our complimentary consultations linked in our show notes. And a huge shout out and thank you to everyone who's subscribed and left us a 5-star review. If you haven't yet, be sure to subscribe and also leave us a 5-star review. It's one of the best ways to support us as a small business. And also be sure to share with your friends and colleagues on social media, through text, email, or however is easiest. It means the world to us that you're supporting our content and helps us make more to support you in your journey. Welcome back to another episode of the Dealmaking with Laura DiFrancesco podcast. I'm Laura DiFrancesco, founder of Dean Street Law. We've closed over $10 billion of transactions since starting Dean Street Law 5 years ago. We specialize in lower middle market mergers and acquisitions, particularly in the entrepreneurship through acquisition space. And I'm taking my knowledge and experience negotiating mergers and acquisitions for over the last decade and making it more accessible through this podcast, which I'm really passionate about. I want to shout out and say thank you to all of our subscribers and everyone who shares the podcast. It means the world to us. So if you haven't yet, take a moment to subscribe and be sure to leave us a 5-star review. It is the best compliment you can give to a small business and a huge support for our podcast. So thank you. Today's topic I'm really excited to talk about is real estate in mergers and acquisitions and how that impacts your transaction. Specifically, I became a lawyer because of experience in real estate, and there's so much that you can see in real estate in negotiations and also that you can learn from real estate to apply to mergers and acquisitions if you're new to the mergers and acquisitions space. With that said, real estate can be incredibly influential in your M&A deal because there's so many different implications that it has, whether the target company or business for sale includes leased real estate or owned real estate. So we're going to talk about decision making and implications from a real estate perspective, whether it's leased or owned, talking about how to analyze a lease, how to analyze the purchase of real estate, what legal implications it will have for you, how it will impact your transaction, all of that and more in this episode. So be sure to subscribe for more episodes like this, and let's get into the topic of leased versus purchased real estate. One of the biggest questions that I ask as soon as I get on a complimentary consultation with potential clients is real estate involved in the transaction? And oftentimes they say no. Even though real estate actually is involved in the transaction, it is just leased instead of being purchased. So even if there's a lease, it's still going to be very influential on the transaction. If it's being purchased, even more so. But as you're talking to attorneys, as you're conceptualizing your transaction, the real estate component is very important because it has a lot of far-reaching implications. With respect to whether it's leased or owned, it's also really important to understand whether that property is owned by the seller and could be potentially sold within the transaction, or whether it's owned by a third party that is not going to be impacted by the transaction, but which you will need to get consent from in order to transfer the business. In most situations under a lease, you will see change in control and assignment provisions that will require landlord consent the vast majority of the time. So then you have a third party consent that you need to obtain. So even if it's owned by a third party, it's still an important component of closing and preparing for closing, because getting that third party consent will determine whether your deal can go through or not. Now, when you're thinking about the overall structure, let's take it back 30,000 feet and think about how real estate plays a role in the business at hand. there's so many different things to think about that not only you should think about, but I can guarantee you your lender will be thinking about, as well as your investors and anybody else involved in the transaction, which is, what purpose does this real estate serve? In certain businesses, the real estate is really optional. Maybe it's a business that could be remote, but there's real estate involved because the seller specifically works out of that space, but maybe none of the other employees do. Or it could be real estate that is really not aligned with the business and that you would like to exit as soon as possible because it just doesn't fit the business, or it's not the best location or whatnot. There are a lot of things you need to think about in terms of your flexibility to change locations. Certain businesses are very easy to pick up and go somewhere else, whereas others are very hard. When you're talking about manufacturing and custom built machinery to manufacture something, a lot of the time, not only is that custom built, but it's custom built into the actual facility, where that may cost hundreds of thousands of dollars and months or years to install in another facility. So in that type of situation, your lender is going to be thinking of the risk of the location risk of the business and how easy it is. And that's why you'll see a lot of the SBA loans will require a new lease for the same term as the loan if there's any sort of relocation risk within the business, where it would put the business down for a certain period of time or put undue stress on the finances of the business or something of that nature. So you should be thinking about that relocation risk and flexibility as well as you're analyzing this. And of course, what is your future vision for the business? What does it need now? What does it need in the future? All of those are going to help you start to shape your thoughts and opinions about the real estate involved in the transaction. It's also really important to consider if, let's say, the seller does own the real estate, are they interested in selling? Are they not? Could you get financing for it? Does it actually improve the financing of the transaction? We're going to talk about that a little bit more in further detail later. But sometimes actually having real estate involved in the transaction means that it's easier to finance the business because it has a tangible asset, perhaps in a business that was less easy to finance. In addition, you want to be thinking about, if the seller does own the real estate, have they been paying themselves a fair rent, or has it been arbitrary for tax reasons? And so if they either plan to lease it to you or plan to sell the property to you, there need to be considerations in there, especially if you're going to lease it from them, with respect to what market rent would be, because they may not want to continue renting it for what it has been, because then when they go to sell it, they're going to have a hard time to sell it if it's not being rented at market rent. In addition, it may be impacting your financial analysis if you don't understand whether the rent that's being paid is market rent or not market rent. So there's a lot of considerations there. We're going to talk a little bit more about the finances as well. But some things to think about too is, how are the expenses being run through the business? Is it considered a triple net lease where the lessor, the tenant, is responsible for maintenance and responsible for taxes, insurance, etc.? Or are those split? So do you really understand the financial situation of the real estate and the financial situation of the business as a whole as you're analyzing these components? All of them will have a significant implication on your negotiations, your purchase price for the real estate, or your rent, or anything that is going to necessarily come out of all of those discussions, because there are a lot of permutations from there. So we talked about really understanding what the current situation is, whether it's owned by the seller, whether it's owned by a third party. Is the seller interested in selling? Is the seller not interested in selling? How flexible do you have in changing your lease location or your real estate within the transaction? And then also, what are your future goals? How does this real estate serve you in the future? Is it taking up capital that would be better served elsewhere? Do you need more flexibility? Do you desire less flexibility and want more long-term gains? So those are going to be some things we're going to talk about in further detail. Of course, ultimately, all of those things will come together to help you decide, do you want this real estate? Is this real estate important to you? It's always best when going into these negotiations to think of what you want and how you need to position yourself to get that. But in addition to that, let's say things don't work out, can you still be in a situation that supports you? So let's say you don't want to rent this real estate and it's not the right space for you. But it would be a lot better to lock in a lease term that's going to be beneficial for you and have termination rights than it would just to say, I'm going to terminate this lease immediately, and then you're scrambling during your transition period to also relocate the business, and it's all a stressful situation. So get honest with yourself about what you want, but then also don't just throw the baby out with bathwater. Make sure that you have backup plans so that if you do need this real estate, you have access to it, and it's better to have termination rights than no rights to the real estate to begin with. And then your funding, your lenders, start talking to them early about the real estate in the transaction, whether you're bringing on investors or you're looking to get a loan for the real estate. All of those parties that are going to be involved in the finance aspect of the transaction should really be having early conversations with you about the real estate, because it is such a material aspect of the deal, negotiating the purchase price and the value of the real estate and whether the deal will go through with or without the real estate. It is so much easier to get that ironed out in the beginning and do it right from the first time than to have to go back and renegotiate, which I've seen multiple times, people having to go back and saying, oh, now we're going to add in the real estate and now we're going to renegotiate all of the purchase price and all the financial dynamics within the transaction. That can really cause significant delays. In addition, it really can change if the seller expects to sell the real estate and then you're unable to get the financing for it, and then you have to back down, and then that purchase price may seem a lot less impressive because you're taking out the value of the real estate. There's a lot of nuances there about purchase price allocation that we won't get into in this episode, tax ramifications of all those things. We're going to just go over the overviews, but those are a couple of elements to start thinking about. When it comes to navigating corporate law, entrepreneurship, and managing small businesses, experience matters. Dean Street Law is a boutique corporate firm specializing in mergers and acquisitions, and additional focus in real estate, commercial transactions, finance, and corporate governance. With over $10 billion in deals closed, Dean Street Law has extensive experience representing hundreds of clients in thousands of transactions, from small businesses to Fortune 500 companies. Whether you need startup guidance or advice on closing multi-million or multi-billion dollar deals, we're your trusted partner every step of the way. Visit deanstreetlaw.com in the show notes to schedule a complimentary consultation. Now, let's say there's a current lease involved in the transaction. So how are you going to be analyzing that lease and reviewing it? Of course, we, as your attorneys, Street Law, if you'd love to work with us, we would love to work with you. And you can apply through a complimentary consultation in the show notes. But your attorney will be going through the due diligence process and reviewing the lease terms, but you should also independently know what to look for, because it's important to have this knowledge in the back of your mind so that you can discuss it with your attorney as well. As we talked about, what flexibility do you need to have in your business for changing locations? That element needs to be directly analyzed then in the lease. Do you have termination rights? Do you need more flexibility? Would you like to commit for longer? And if you do commit for longer, including renewal terms, are they obligatory, meaning that you have to pay certain things, or can you terminate prior to a lease term, or in the middle of a lease term, or in the middle of a renewal term? A lot of the time, if you are getting into something, for the most part, a landlord has more beneficial terms in a lease than a tenant, because typically they're providing their form, and a lot of the time, a landlord will have a one-sided lease. That's not all of the time, but a lot of the time it will be a more one-sided lease, and you really have to go through a lot. If you're going to be, you also have to determine with your lender, do you need to have a new lease? Does a new lease need to be negotiated because either the term's running out or the lender needs security about relocation risk, and can you negotiate a more fair lease, or does the lease on its face appear to be more fair? Your attorney will really be able to help you parse through these things, but things to think about. And then in addition to that, having the lease specifically, you want to be thinking about your operations within it and your growth phases and where you plan to go, and incorporating all of that into your planning with the lease, the flexibility, the lease term, the renewal term, and the termination rights. All very important, especially if you plan to sell the business at some point, making sure that you have reasonable assignability and change of control provisions, so that if you sell the business, that the landlord will provide consent that will not be unreasonably withheld, or you could provide that if the person that's being assigned or coming into control in the event of the sale of the business has a as good or better financial position, or the business has as good or better financial position, then they will accept the change in control or accept the assignment. So there's a lot of different ways that you can negotiate those. Of course, most landlords are going to have a challenge with having favorable assignabilities and change of control provisions, but they are very important to negotiate as you are going to not only think about growing this business, but eventually exiting it as well. In addition, the important terms to think about, as well as the term, the renewal, and termination, are also rent. Rent is so important. Financial term. A lot of the time, people don't want to negotiate this in the letter of intent. They want to wait. It is one of the most highly negotiated aspects of a transaction. If the seller owns the real estate, negotiating that rent is going to be one of the most highly negotiated aspects. So do not wait until the last minute to start discussing this. And if the seller needs to get a market report or something like that from a realtor or from an appraiser because they have not used market rents, that does take a lot of time, and it is something you should be thinking about in terms of lead time and closing timelines as well. In addition to that, the other key aspects to analyze in the lease are maintenance responsibilities. Are the core functions of the building and property the tenant's responsibility or the landlord's? Some of the biggest expenses are going to be roof and core systems like HVAC, electrical, plumbing, parking lots, those types of core systems. Whenever possible, we do try to negotiate it so that the landlord, seller takes care of those core systems and biggest expenses, because if they've been delaying replacing the roof for 20 years and it needs to be replaced, they would have better knowledge of that than you would. But it is always going to be something that the parties agree to, negotiate, and make sure is fair between them. In addition, understanding the control that the tenant has over the property, build outs, the ability to change anything, the ownership of fixtures, especially if they are very expensive fixtures and whatnot, and improvements. Those elements are some of the most influential. With that said, usually leases are anywhere between 20 to 60 pages, sometimes longer. So there's a lot that we review in due diligence, but those are a few places to start. The lease negotiations will oftentimes impact the purchase price negotiations as well, which is why I mentioned that it's one of the most important things to get done if you can by the letter of intent stage, if it's a non-competitive situation. But if it's a competitive situation, then as soon as possible after the LOI has been signed, you absolutely want to be focusing on negotiating and dialing in the lease expense and the lease terms. One of the biggest things that we do differently at Dean Street Law than any other law firm that I've ever heard of is as soon as we're engaged, after the LOI has been signed, we provide a material deal terms list, closing checklist and timeline, and a due diligence request list. Now, that material deal terms list will prompt you for all the things that we need to discuss. We also start weekly meetings with our clients so that we can tackle these hard issues early, so that there isn't a timeline where they're investing in QOV, in legal, and then they get to the 12th hour and they still haven't decided this $100,000 a year, potentially more, lease figure, and that becomes the biggest issue that starts making the deal go sideways. That's why we prepare our clients to be negotiating early and making sure that they have hard conversations as early as possible to the greatest extent possible, that it makes sense from a strategic perspective as well. And so overall, the seller's looking to get a certain amount out of the deal, whether that be with the lease, with the purchase price, with the compensation for transitioning and consulting or providing transition services or employment services. There's a certain amount that the seller wants to get out of the deal, including the seller note potentially as well. So this being a key economic aspect of it is why it's going to be one of the biggest, most highly negotiated aspects. And so there can be levers, which is why when you want to negotiate this as early as possible, while there are other open levers on the table as well, because if you can get to the overall picture that the seller wants, while also balancing both the purchase price and the lease and the compensation and the seller note and everything else, it's better to negotiate these things while you have other open levers before all of the levers close, and then the deal gets very sticky for the buyer and becomes, and maybe less so for the seller. So as a buyer, you want to negotiate this earlier. As a seller, I think it's also very important to get this ironed out early as well, because you don't want to be spending too much on legal fees and your time investing when you can't come to terms on a reasonable lease and rent payment. The other impact is with the ownership analysis. So let's say you have a situation where you do want to purchase the real estate, or you want to explore the option to purchasing the real estate. To circle back quickly on the lease elements, if there is any opportunity in the future for desiring to purchase the real estate, you always want to include that you're going to have a right of first refusal and a right of first offer, and potentially even make it a lease with an option to purchase. Those are three different mechanisms that you can take a situation from leasing it to owning it through a legal mechanism. And to explain them very briefly, a right of first offer is when the seller is ready to sell the property. They would have the obligation to give the tenant the option to provide an offer to purchase. Whereas a right of first refusal is where the seller desires to sell the property and the tenant has the opportunity and right to match an offer provided by another third party. Then there's also the lease with the option to purchase, which is where the tenant has the right to purchase the property upon certain circumstances. And that may also include that a portion of the rent be applied to the purchase price, may or may not. Those are just a couple of different ways. It may be a right after a certain period of time, an obligation to purchase after a certain period of time, or some sort of other trigger. Those are a little bit of quick sprinkles of if you have a leased situation and you may want to purchase it in the future, you would want to include those in your letter of intent. We do provide flat fee letter of intent negotiations so that we can discuss all of these options. These are things we go through in great detail so that we can structure your letter of intent to support you throughout the entire transaction so that it's a good foundation for your negotiations and structuring a deal well. When you're considering the ownership aspect of it, there's a few things. First, valuation, of course, the most important thing. Sometimes the seller will get an appraisal or they'll get a market report. You do want to make sure that you're doing your own due diligence on valuation and, of course, putting this whole thing into consideration with the overall economics of the transaction and how the business is able to support the acquisition, if it is able to support the acquisition, and overall making sure that their analysis is a fair analysis as well, because you can always provide an analysis and you can usually find examples to support a certain position. So most of the time, if someone provides a market report, whether it's buyer or seller, it's going to be more favorable to their position and have more examples that support their position. Of course, some people want to negotiate fairly and in good faith, and act in the best interest of both parties and just find something neutral so that the deal can get done. There are plenty of people like that. We love working with folks like that too. But just so you know, if someone's providing a market report, most of the time it's going to be favorable to them. And then as well as that, it may be something of interest to purchase the real estate as an opportunity for value appreciation, not only growing your investment through the top line revenue of the business and potentially decreasing costs in the business, but also through the natural appreciation of real estate. Of course, there are up markets and down markets, and you do have to do thorough market analysis. It is so key to understand location, and the market dynamics. How well is this piece of real estate priced within the market, and how will the rent compare to financing it? All of those are going to play into your valuation. And of course, as I mentioned previously, you definitely want to be having conversations with your funding sources, whether that be lender or investors, early on to make sure that you are well equipped to be able to fund a transaction if you're intending to purchase the real estate. And then in addition, having the purchase of the real estate is going to enable you a lot more control than you would have in a tenant situation, and you'll have more fixed long-term costs. So you'll know that at some point in 30 years, or well, most mortgages, I would say, and most loans for real estate that are commercial are going to be more usually in the 10 to 15 year. If it's residential, you'll see more like 30, but in most of commercials, you're going to see 7, 10, 15 year loans so that you can finance those. And I would say sometimes 15 is even on the very long side of the horizon, usually 7, 10, a little bit around there. So it can provide you a little bit more certainty of when you're going to have ownership instead of paying lease payments and not just going to a third party, that you're actually investing in equity in the property and supporting your long-term vision. With that said, there's a lot of capital allocation questions that you need to consider, because if you are allocating capital to real estate, even if it is going to improve the value of the real estate, you also have to consider maintenance costs, overall operational and ownership costs. So you become the property manager. And in certain businesses, that's not that hard. In other businesses, that becomes actually another job and another layer to the business that becomes complex. And so you have to decide, is it better to be a property manager and put capital into the elements of real estate that may not serve me, or is it better to put capital into the growth of the business and just accept the lease as paying a third party and not contributing to the value, but instead of having to replace the roof, you know that you're only paying a certain amount per month for rent, perhaps a rough estimate of common area maintenance costs if it's a common area property, or a more fixed and certain monthly or short-term cost to the real estate. So it's all dependent on your capital allocation preferences and your growth preferences to be able to grow the business and allocate capital in the way you would like to grow your business. It does have, of course, higher capital requirements, especially from the beginning when you're purchasing, making sure you have enough for the down payment, the maintenance and repairs on an ongoing basis. And then, of course, it also reduces flexibility in changing locations. It depends on your marketability of the property and your overall flexibility already in being able to change locations. But of course, purchasing the property can diminish in a lot of ways the flexibility of expansion to other properties or changing locations if there's another location that ends up being better. You definitely want to spend your time upfront considering all of these things so you don't get it locked into a 10-year lease with minimal or no termination rights and have to sit with something for a long time that doesn't fit. So it is a lot to be going through this process while also buying a business, but important considerations to make. Thinking about buying a business? Unlock the secrets of successful acquisitions with Acquisition Insights, your legal roadmap for success. With over 81 modules of video lectures, written materials, guides, and checklists, we provide in-depth guidance to navigate every step of the process. From initial interest to closing the deal, get the expertise you need to make informed decisions. You can also access our battle-tested templates in the Acquisition Insights course and templates bundle, including our template LOIs, letters of intent, pre- and post-LOI due diligence request list, material deal terms lists, and more. Visit lauradifrancesco.co/the-shop today and take the first step towards buying your dream business. All the links are in the show notes. So let's go on to legal implications. How will this legally impact your transaction? There's a few different ways. First, it's going to impact scope of work. So when you're negotiating a new lease is going to be a bigger process than just obtaining a landlord consent. In addition, if you are negotiating the entire purchase of real estate, that's going to be a bigger process and bigger scope of work than just negotiating a lease. With that said, there's also an entirely separate scope of work if the purchase of the real estate is within a stock purchase and the real estate is owned by the company that you are purchasing the stock in which case you don't sell the real estate and the real estate ownership does not change, but the change as the ownership of the business. That would be your most simple way to buy real estate. It does become considerably more complex from there, and it can just go skyrocketing in complexity. So you could have real estate that is owned in a separate company, and you could transfer the stock that way, or you could do it as an asset sale where you traditionally sell real estate from one entity to another or one owner to another. There are a lot of pros and cons to each of them, but they do graduate up in complexity, especially when you have different parties that are buying the real estate on the buy side. So let's say you want to put the real estate in a different company than you're buying the rest of the transaction. You're basically doing two separate transactions, especially if maybe the sellers on the sale of the business are different, but maybe related to, but still different than the sellers of the real estate. You essentially are just doing two entirely different transactions in that scenario. So there's a huge difference in legal scope of work, complications, the amount of documents, the amount of work that needs to be done, graduating all the way up. And then, of course, that implicates cost and the costs associated with doing a simple landlord consent versus a lease versus a sale of real estate within the overall transaction, but not as a separate transaction because it's just an asset within the business that the business is already being sold versus an entirely separate transaction where you have real estate owned separately than the business and being sold separately and being purchased separately as well. So we can get into all kinds of complications there. Needless to say, we are happy to talk about all of those with you, discuss them in further detail, talk about the legal costs associated with this. We go over all of these on our complimentary consultation calls. I will say one of the biggest things to note in your legal implications in all of this is timeline, because even something as simple as a landlord consent can really derail the deal if it's not approached early enough and if the parties aren't working diligently enough. You do not want your landlord consent, your third party consent, to be the last thing that you're waiting on to fund the deal. It's not a pretty scenario waiting on a third party. So you do have to start on it early. You do have to make sure that you have everything you need for closing well in advance of closing so that these types of things don't slow down closing. When you have third parties involved, you always want to be thinking early, thinking often, making sure you're nailing down those aspects of the deal so they don't derail anything when it comes towards closing. In addition, when you're thinking about the complexity of negotiating a lease with the seller or negotiating a new lease with a third-party landlord, thinking more timeline. It's kind of hard once you get real estate involved to do a deal under 60 days. You can, but it's very hard, especially from a funding and financing perspective. Most lenders can't do a deal in under 60 days. When you're talking about buying the real estate, it may take even longer. There's a couple reasons for this. So one of the biggest legal implications of real estate is in terms of financing, if you are getting it financed, a lot of the time we'll also need to do an environmental inspection. And so an environmental report phase one is your typical beginning of this, but depending on the property and the findings of phase one and the use and everything like that, the lender may also require a phase two. I have seen deals drop the real estate sale aspect and make it into a lease because of unfavorable findings in phases one or phases two, or them taking too long. Phase one and phase two take a long time to do those reports and evaluations and inspections and all of that. And in addition, one small thing coming up, if it's an auto repair shop and they have oil, most likely there will be some sort of oil spills, even if it's non-material, even if it's such a small percentage. And those can really inhibit lenders from lending if there are issues that come up in the phase one or phase two. So it's really important in terms of timeline to think and ahead, make sure you're communicating with your lender on what you need for the acquisition of the real estate, making sure that you are pushing forward with your attorney, getting the green light, going forward, making sure you're doing all the things that you need to do, especially when we have all of these moving parts that real estate introduces. So if the real estate is really important to you and the transaction and the business, make it a part of your letter of intent, make it a part of your elements that must be received, your closing precedents, the elements that you need to receive in the deal to be able to close. And so when you're thinking about the consents that you need or the approvals that you need, you may also include a environmental report for phase one and it being satisfactory to the lender or something like that in your conditions precedent for closing. So these are all things that we talk about through the letter of intent process, through our engagement working on the real estate aspects of the deal. But make sure you're building enough timeline. If you're doing a purchase of real estate, I would absolutely include at least 90 to 120 days to get that done, because a purchase of real estate, you're going to have to do your inspections, your facility, go over the facilities, make sure you understand all the different aspects of it, potentially a phase one, maybe even a phase two. And then I would also set your closing timelines. In those types of situations where you're waiting on third parties or you're waiting on elements that both parties want to do the deal, they've not ironed out the purchase agreement, but we're still waiting on reports back or something like that, you might sign the purchase agreement and have the closing within a certain period after the receipt of all of these conditions precedent to closing. And so when you have that, you still need to have enough time for the deal to restart and get all of the documents sent to everybody. So you definitely want at least 2 weeks, I would say, from when those reports are received that closing would be triggered. And I always think it's better to have, if the parties agree, to have an open timeline that is triggered by the completion of the events that you know you need to have to get to closing, than it is to say that the parties will close by March 31st, hoping that by March 31st, the phase one and phase two have come back clear and everything's good, because you don't want a deal to fall through purely because you have more complexities around it that need to be addressed that will inevitably impact the timeline. I hope that all of these have been helpful in just glancing over a few of the elements that are going to occur when you have real estate involved in the transaction. Real estate is one of my absolute favorite things in law and mergers and acquisitions. Molly, do you have anything to add? Molly also loves real estate. Molly is a farm girl. She's been a lover of real estate like her mama for a long, long time. So I hope you have a wonderful time. Happy deal making. If you enjoyed this podcast, please be sure to give it a 5-star review. Give it all the love, right, Miss Molly? Give it all the love. Share it with friends. Share it on social media. Share it with colleagues, anybody who it would benefit. And be sure to also let us know what you'd like to see in the next episode. I do think the girlies are trying to say that this is all for now and we need to go out and play and enjoy real estate and enjoy all the wonderful things that it involves. So we will see you in the next episode. See See you later. Happy deal making. Thank you so much for joining us on this episode of the Dealmaking with Laura DiFrancesco podcast. I hope you found today's discussion insightful and that it brought you one step closer to mastering the art of mergers and acquisitions. If you enjoyed this episode, please be sure to follow and subscribe to Dealmaking with Laura DiFrancesco on your favorite podcast platform so you never miss an episode. And if you found value in our discussion, please leave a 5-star review. It would mean the world to us, and share this podcast with your network, friends, and colleagues. For more in-depth resources, be sure to visit our website, deanstreetlaw.com, where you can find articles, guides, and more information on our services. Don't forget to follow us on social media for the latest episodes, updates, tips, and exclusive content. You can find us on LinkedIn, Search Funder, at LMDFrancesco on X, and at Dean Street Law on Instagram. Join us on our next episode where we'll explore more deal-making insights. Cheers and happy deal-making.